You were Destiny Collins. We issued a warrant for your arrest because you failed to appear for court, ma'am.
The paperwork, I told him the same paperwork. It said I was supposed to appear today. If that's the case, my bail's bond company should have told me the same thing. But my court date was for today.
You were ordered to appear 11/22 of 24.
I got out of jail that day. I was released from jail on Wednesday of this week, last week that just passed. So there was no way possible I could have made it to court that same day. I got released from jail again. And I didn't get released from jail till Wednesday at like 1 o'clock in the afternoon. And then also I have the picture. I didn't bring the physical copy because I forgot it, but the paperwork that they gave me when I was leaving, that said my conditions. I have a picture in my phone with my name on it. It says today at 8:30 in the morning. So I showed up today. If that was the case, I would have showed up when I was supposed to come to court. So I don't get that. And I just sat in jail for a week and a half. I cannot go back.
You issued the warrant on the 22nd, right? This is Miss Collins. She's not on docket today.
What's the case number?
252-6615.
Can I show you the same picture?
Stop right here. This is the moment courtroom confusion crashes into the reality of official paperwork. Destiny says she simply followed the release papers she received, yet the court record shows a missed appearance several days before. That detail matters because in legal terms, a failure to appear instantly activates a warrant. But here's the critical point. If the court itself produced conflicting dates, then that's not intentional defiance. That's a breakdown inside the system. So here's the question for you watching. Should someone truly end up behind bars because the system couldn't keep its own paperwork consistent?
She was on the docket on the 20th. She was supposed to be here on the 20th, correct?
The bond paperwork shows, let's see.
I'm confused. I'm confused.
It's not opening on the
Can I grab my phone and show you my
Don't
picture?
talk to the prosecutor, please. You're not allowed to. I'm trying to figure out what's going on. Because if there's a problem and it's not your fault, I will reinstate your bond.
Judge, so on 11/20, she failed to appear. Defendant not present in holdover is what Jamae wrote on the reset. So she wasn't brought up on the 20th. So she rolled it to the 21st, and then the surety bond was posted. The surety bond says 11/20. So it seems to contradict itself. The 20th.
So whoever wrote the bond did a mistake because they put
Whoever handwrote 11/20
back in time as opposed to. So what you said, you have paperwork that says that you're supposed to be here today?
I left the physical paperwork at home, but I had my brother send me a picture because I forgot it. I can show you.
Yeah, sure.
And just like that, everything turns. A single photo on her phone confirms the correct court date and time. The warrant falls apart, and her bond is reinstated. It's a clear reminder that documentation defeats explanation almost every time. Watch how quickly the judge shifts direction once the proof appears. No arguments, no long debate. But here's the reality. Even though this mistake gets corrected, the original charge is still there. So here's the question for you. When clerical errors send someone to jail, should the courts be required to apologize, or is simply fixing the mistake enough?
And you can give it to Deputy and she'll. You see that it shows today's date?
Yes, Judge. November 26th at 8:30
Okay,
a.m.
all right. Yep, you're right. Okay, I'll reinstate your bond. So it looks like while you were in custody, they appointed you a lawyer. I don't know that Martin even knows I mean, there's no way he's going to know.
Especially if she's not on docket today.
Right.
No.
Oh, I have his number. I'll call him. Let me see. Martin. Hey, how are you? I have a Miss Destiny Collins that's on docket today. Are you in the building? So you were appointed, it looks like, while she was in custody. Say it again? She was in custody in Fort Bend. Huh. Okay. Do you want to stay on the case or do you want me to appoint someone else? Okay, no problem. You just tell me. So that's it? Done. We'll do it. Okay. Okay. Bye. Can you pull up her NCIC, please? So we can. I'm going to take Martin off.
Okay.
Because he's not working with us. And do you mind appointing someone else for the time being, please? Ms. Collins, you're charged with assault, bodily injury. You're facing a year in jail and/or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On August 8th, 2024, a deputy was dispatched to a bar and grill in Harris County, Texas regarding an assault. The complainant worked at the bar as a bartender. Defendant came behind the bar and began striking the complainant multiple times with a closed fist to the face and upper extremities, causing pain. Complainant began to fight back to defend herself. During the fight, a crowd of people surrounded her, and some individuals who she did not know began to stomp and kick on her while she was fighting on the ground. Complainant
Stop and kick the complaining witness.
That's not true.
Stop, please.
Yes, the complainant stated during the fight, a crowd of people surrounded her and began to stomp and kick her while she was fighting on the ground. She stated that the fight lasted approximately 2 minutes. The complainant and the defendant did not know each other and stated that she did not.
Now the tone shifts and hardens. The judge lays out strict bond conditions. No alcohol, no bars, and random testing. Because this case does exist in isolation. A prior probation history changes the entire equation. Judges aren't only looking at what happened this time. They're deciding whether someone could pose a risk to the public. This is the difficult balance courts constantly face, protecting public safety while avoiding punishment for mistakes a person didn't actually make. So what do you think? Are these conditions fair, or are they setting her up to fail?
Know the defendant well enough to fight her. The complainant stated the fight ended because someone yelled out, "I'm calling the police."
Okay. Tell me, does she have anything else that's open at the time now?
She's currently on probation out of Galveston County for theft. And I think you had mentioned something about Fort Bend, so we're looking for.
Lord, we're hitting the Tri-County area now?
We're not showing anything out of Fort Bend, Judge, but she is on probation out of Galveston right now.
She may have been in custody in Fort Bend. I don't know. So run full NCIC, please. Ms. Collins, I'm going to find that there's probable cause to go forward with the case. I'm now ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. I'm going to do everything in my power to protect my public in every single way, shape, form, manner. And if you become a danger to my public, I am first off going to put you in jail. Next off, I'm going to make your bond so high you're going to flip. Do you understand? Do not go back to this bar or any other bar. I'm prohibiting you from going to any establishment where 51% or more are beer, liquor, any kind of clubs. You're not to go anywhere of this nature. Do you understand? Does she have a felony theft or does she have a misdemeanor theft? And then what else is open? What kind of criminal history are we talking?
Felony theft, Judge. And I believe that's her only history. And Alex is looking into the Fort Bend case as well.
Your Honor, I don't have any record of her case in Fort Bend. Looking at the county clerk website in Fort Bend, I don't see any cases open with her name and date of birth.
So the only other thing you see is it a probation that she's on?
Yes.
For Galveston.
Oof.
Yes, Judge.
Yes, Judge, 2 years deferred on from Galveston.
How old are you, ma'am?
23.
What do you do for a living?
Right now, I work 2 jobs and I live alone. I live in the Fort Bend County area.
How much money do you make a month, ma'am?
My monthly income, I say my intake probably about 3,800.
I need you to fill out an application because I don't know if you're going to qualify for an appointed lawyer, ma'am. And I'll take a look at the application. The only thing I'm going to tell you is that when you're on felony probation, you're supposed to be extra special good. And when you're not, they usually file motions to revoke. So I would be on the lookout because if you're on probation or parole at this time, it's very possible that they issue a felony warrant in that case with the fact that you picked up this new case. So understand, no alcohol, no drugs. Do you understand? Okay. Do you mind giving an application, please? All right. I'm going to have you fill out the application and then we'll do not leave until you sign all our bond conditions, ma'am. Okay. You were charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Officers were conducting a trespass investigation at a gas station in a high crime area where narcotic/gang activity frequently occurs. Officers observed the defendant's vehicle parked for approximately 30 minutes in front of a no loitering sign at the gas station. The officers approached the vehicle and observed a strong odor of marijuana. Officers then observed in plain view a handgun between the driver's seat and the center console.
All right, Mr. Hunter, I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license?
No, sir.
You are not allowed to drive.
Sir.
Do you understand?
Yes, sir.
If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
You're on probation or parole at this time?
No, sir.
You are now working your 4th case within the last year, your 3rd gun case. Tell me, what do you do with yourself? Do you work?
Yes, sir.
What do you do?
I work at Family Dollar.
Do you work full time? How much money do you make a month?
$1,600.
I'm glad that you're working. I want you to continue working. Did you graduate from high school?
Yes, sir.
You did? Great. Okay. Do you want to apply for an appointed lawyer?
Yes, sir.
Okay. No more dope. I'm going to test you. And if I find that you continue to smoke dope, it's not going to go well. Do you understand me?
Yes, sir.
I will test you 40 to 45 days from today. If you test positive, it's not going to go well between us. You stop now. Do you understand?
Yes, sir.
There will be consequence because it's the 4th case. And I'm ordering you now not to consume alcohol or illegal drugs. And I'm going to test you like crazy. Do you understand?
Yes, sir.
I'm going to put on an application. I'm going to have you come up here, swear to us that you're not going to drive. I'll get you to Stephen to fill out the application. We'll have you sign a receipt with Victoria, and then we'll have you hang tight.
Will there also be state bond conditions?
No, because I'm going to monitor him and make sure he's not using. So we'll just, everything will be withdrawn.
Next is page 10. Bumper.
Yes, ma'am. Did you say they found weed on him or no?
I don't think it was in her. I think it was in her.
What is your last name, sir?
Mumford.
Page 10.
Thanks. Mr. Mumford, you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On October 4th, 2024, officers were dispatched to a call at a parking garage in Harris County, Texas. Officers made contact with complaining witness who stated that she and her coworkers, including the defendant, were working inside the parking garage. And the complainant messaged the defendant asking where he was located. And the defendant suddenly arrived at the third level where she was located and began to yell and scream at her. The complainant stated he threatened to beat her ass.
Were they together at the same place?
They were on the same, so they both work at the parking garage, I believe, and they were both on the same level. Like it was in person, the threat was made to her in person.
Did you say she was in fear?
I don't see that in the Dunes, Judge, but let me really quickly the offense report. I don't see that alleged in the OR, Judge.
Mumford.
So the only thing the state would say, Judge, is our position is, I know it doesn't say that complainant said she was in fear for her life, but the charging instrument, it's not one of the elements we have to prove. We just have to prove that the defendant intended to place the complainant in fear of serious.
I don't know. Let's see. A person commits an offense if he threatens to commit any offense involving violence to any person or property with intent to place any person in fear of imminent serious bodily injury.
So, and Judge, just to remedy the issue, we checked the probable cause affidavit on the charging instrument. On the PC affidavit, it does say that she stated she was in fear for her life.
That's the only thing I want to know is she in fear? How do we know?
Yes, Judge.
Because a lot of people make these stupid ass threats all the time, and it's just.
I understand, Judge.
Tell me what it says. And does she say that she was in fear?
Let's see. Oh, it does say that the defendant came to level 3 where she was located. He began to yell and scream at her, threatened to beat her ass. She stated that this scared her and made her in fear of serious imminent bodily injury.
And where is that?
This is in the charging instrument, the PC paragraph.
That's just the charge. But I get it. That's just because they put that in the charge. Nowhere in the OR does it say that she's in fear. Nowhere else does it say she's in fear. That's just because they always put that on every information with regard to this.
I understand, Judge. And
Yeah.
the only position we have is that it's not one of the elements the state has to prove.
I don't agree. I'm going to find no probable cause in your case. The only thing I'm going to tell you is be careful, really. Words
Yes, sir.
have meaning. Words can hurt, right? Pen is mightier than the sword. Words can hurt. Be careful. All right. Okay. Take a seat, please.
All right, Judge, we have one Spanish arraignment, page 11, Perez, come on up.
You are Namus Perez Cajax?
Yes.
Sir, you are charged with failure to stop and give information, leaving the scene of an accident without exchanging information. You are facing up to 6 months in jail and/or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Officers were dispatched to a minor crash. Upon arrival, officers observed damaged vehicle that was no longer drivable. Complaining witness advised that a black vehicle disregarded the stop sign. Complaining witness advised the vehicle stopped briefly before driving away. A witness saw the crash and took a picture of the license plate. Officers ran the plate and found the defendant was the registered owner. Officers made contact with the defendant, and defendant agreed to meet officers at scene of crash. Defendant admitted to being involved in the accident. He advised that he is the owner and the only driver of the vehicle. The defendant advised the officers that he did not see a lot of damage and saw that the complaining witness was uninjured, so he left. Estimate of damage is $1,000.
Mr. Perez, I'm going to find that there's probable cause to go forward with your case. Tell me, are you a United States citizen?
No.
Are you in this country with or without permission?
Without permission.
What happens if you go to jail, Mr. Perez?
I don't know.
Are you in this country with or without permission?
Está en el país con o sin permiso. Without permission.
I want you to think,
Quiero que piense.
what happens if you go to jail?
Bueno, si voy a la cárcel, pues voy a cumplir con lo que diga el juez.
Well, if I go to jail, I'll comply with what judge says.
You're not in this country with permission.
Está en el país.
Immigration sweeps the jail on a daily basis, every 6 to 8 hours. If you go to jail and immigration finds you there, they will put a detainer on you and you will sit in jail until first this case is over with, and then you will be shipped off to immigration, or you will sit for another 6 to 9 months waiting for them to do whatever they're going to do. If you don't want that to happen, then do not violate the conditions I put on you now. Number 1, do not pick up a new case. Number 2, you do not have a Texas driver license, so you are not allowed to drive. I am having you sign a promise with me today. This is an affidavit that you're not going to drive. And I don't care what is going on in your life. I don't care if you need groceries. I don't care if someone has to go to the hospital. I don't care if Bambi gets run over and needs to go to the hospital. You get into a car and drive. You can be doing a substantial amount of time in jail. Do you understand?
Muy bien.
This is an affidavit you're signing, promising me that you're not going to drive. I'll have you first sign this. After that, I'm going to get you to Victoria. We will have you sign a reset. We are going to get you out of here. You need a lawyer. So we are going to give you time to go hire a lawyer. I'll have you sign the reset. And after that, you'll be free to go. When you come back, please have a lawyer. Do not pick up any more criminal cases. Do you understand? Okay.
Thank you.